development. And when that debate regarding the very idea of development entered the human rights language, then we also find more criticism um, within the human rights community, whether human right to development can actually be called a human right. Now, what we see and what from the ongoing debate or the contemporary debate on the right to development is that third world leaders question the link between development and exploitation. So the main concern for third world countries is that how development practice is actually leading to the exploitation of natural resources or exploitation of the labor forces or the exploitation of environment in the guise of development. On the other hand, environmentalists also have pointed out the consequences of development in terms of ecological destruction, degradation, repletion of natural resources. Local politicians decry the displacement of populations and increased urbanization. These are some of the issues that always recur or keep on occurring or keep on emerging whenever we talk about development or whenever we talk about the very idea of development as human rights. Even a more radical view in the context of development as human right argue that what we find or what we are observing in the name of development is actually an act of violence. So how do we then understand the current practices of development in the context of the human right to development? The concept of development, as we have discussed already, is a right to development, and that possesses a number of important questions. Now, these are some of the questions. I mean, you can also find out more questions. You might encounter more important or pressing questions, but these are the questions that I found important in terms of understanding how we look into the current practices of development. And when we try to interrogate or try to examine, try to understand the current practices of development, then obviously we need to look into these questions and try to find the answer that, to these questions. And not only that, I mean, whether we are really able to find answer to these questions. So first question is that the right to develop is the right to development all about political discourse. So what we find in the international human rights discourse or the international human rights language is all about right discourses. So we have looked into the Declaration on the Right to Development, which prescribes or proposes the very idea of development, an inclusive idea of development, the very idea of participatory development. But is the discourse about development, is the discourse of human right to development is all about political language? Is it all about human rights, a language that we find in a particular declaration? Or there is any kind of political dialogue about implementation? So whether the international community in terms of discussing, proposing, conceptualizing, as well as reconceptualizing the very idea of development as a human right, actually engage in any kind of political dialogue that will lead to the implementation of the right to development as a human right. The second question, does the concept of right to development create any entitlements? So when you talk about the rights language or the language of right, does this language of right, that is the right to development, can actually be translated in any form of entitlements that can be claimed? That is, again, a question that we need to find answer. If the right to development cannot be translated into a claimable entitlements, then there is no meaning of talking about this right. A right which cannot be claimed, which cannot be enforced, which cannot be justified or cannot be enforced through legal mechanisms, is an empty promise that cannot be that does not make any concrete meaning in terms of people's entitlements. So the question is, can we actually translate the right to development at the national level or at the international level? Is there any entitlements that the people for whom the very language of development has been proposed can claim those entitlements? The third is that how do we extract the meaning and the substance of development or the language of development that we find in the UN Declaration on the right to development? What exactly the meaning the word development suggests, or what exactly the meaning of the term development in the context of the right to development? And what principles and concepts do the right to development provide in terms of development practice and policies? So what exactly are those principles, what exactly those ideas or concepts that can actually be implemented or that can actually be followed in terms of national or international development practices or development policymaking? Is it possible to give the primacy to the voice of those people who are excluded or victimized by the development practice? So, as I have just pointed out a few minutes back, that a more radical view of the idea of development is that development can sometimes lead to violence. Now, those who are victims of development, whether planned development or unplanned development, as you can see from the picture which I have kind of provided there, people can become a victim, or individuals, communities, or people can actually become a victim of a planned development, means development which projects which have been planned by national governments or state authorities or even at the international level. And what about those victims who are merely displaced by unplanned development? So can we really create a space for those voices who are actually the victim of development practice? So these are some of the questions that we need to find answer, and there is no guarantee, or there is no we cannot really say for sure that we will be able to actually find answer to all these questions in our discussion, because some of these questions are contestable, debatable questions, and the discussion, debate, and the controversy are ongoing process in the language of human rights, in the language of right to development. Now, if we want to understand that what exactly the practice that is followed at the international level or at the domestic level, then obviously we need to understand the nature of the right. What exactly the nature of the right to development as a human right? Now, the UN Declaration on the Right to Development um, prescribes a human right as both a condition and also an objective of development. So there must be the states, the international community, in cooperation with each other, must create an environment, must create a condition for the realization of human rights. And human rights is also an objective of development. What does it mean is that the objective of development must be to protect, to respect, to observe, to fulfill, and to realize the very meaning of human rights. Now, it was the aim of the UN DRD, means the Declaration on the Right to Development, is actually um, um, to respond to concerns regarding the existence of serious obstacles to development. So that was the main concern. And if we try to look back into the historical context or the post-war period or the institutional context of the emergence of the right to development, then we need to keep in mind that the right to development actually emerged in a particular political, economic, or social environment in the 1970s, in the 1980s, right? And the objective of the declaration was respond to certain issues at that time at the international level. And that issue was mainly to identify what exactly the obstacles of development, as well as to complete the fulfillment of human beings and of peoples. That was the objective of the declaration. The right to development, therefore, was introduced as one of the rights belonging to third generation of human rights. Now, generally in contemporary human rights literature, what we find that some scholars have proposed a division or a categorization of human rights. And according to this category, what we find is that there are three generations of human rights, three generations of human rights. And nowadays, also, some scholars propose about the fourth generation of human rights. Now, briefly looking into these three generations, which probably you are familiar already, what we find the first generation of human rights, which talks about the civil and political rights, generally codified in the International Covenant on Civil and Political Rights in the 1966. And as you can understand that the political environment at that time, the Cold War environment. So at that time, mostly the developed world or the industrialized countries in the Europe, what was more important for them is to protect the civil and the political rights. Obviously, what does it mean then? um, the the first covenant or the first generation of human rights were more concerned about the protection of rights or providing freedoms and guarantees, which were mainly the concern of the industrialized countries, in other developed countries. Sorry. The second generation, on the other hand, was more concerned about providing protection to economic, social, and cultural rights. And again, in this case, you also need to keep in mind when exactly this second generation of human rights came into the picture. So generally, what we find, the second covenant, that is a covenant, international covenant on economic, social, and cultural rights in the 1976. So what you see that the 10 years gap between 1966 and 1976. So what does it suggest is that the political, the economic, and the social condition at that time also was rapidly changing, continuously evolving. And therefore, this second generation rights was more concerned about the situation of people or individuals living in the developing countries, in the developing world. And in the 1970s, as I have just pointed out, the context of the emergence of the right to development and this second covenant came into existence in the same period, and which suggests that at the time, third world countries were gaining more influence in the international community. The concern of third world people, their rights, the exploitations, the suffering, where became more, I mean, prominent in the international discussion or in the dialogue of in the dialogue of human rights in the international community or at the UN level. Also, um, more and more countries were gaining independence, and therefore their voice, their concern, became more important at the international level. And following from that, just with a close link between this third generation of human rights, I mean, with the second generation. So what you find that um, then the third generation of human rights were more concerned or was premised on the very idea of solidarity rights and belonging to peoples and covering global concerns like development, environment, peace, humanitarian assistance, and the common heritage of humankind. Now, what we see a close link between this second generation of human rights, the social, economic, and cultural rights, and on the other hand, you find this third generation of human rights, which were merely aspirational, means the third world countries were kind of expressing their concern and voice regarding the condition, their own economic condition, their own political environments, and what was more important for them is a national development, use of natural resources for their development planning, use of the concern for their own people, the protection of rights, the protection of social, cultural, and economic rights in those countries. So what we find is that there's a close link between this third generation and the second generation of human rights. Or you can say that this third generation of rights is more about a kind of reiteration of the second generation of human rights, mostly concerned about social, economic, and cultural rights, but with a very different language. Or you can say that it was much more specific, where the second generation of rights was much more general, broad, idealistic, and this third generation of rights was more in the form of a clear articulation. What is exactly important for developing countries? And what is more concerning, more pressing issues from their point of view. And therefore, the third generation of rights became more aspirational in the sense that they remain at the level of at the abstract level, which probably cannot be realized, or which probably cannot be enforced, or cannot be actually implemented in practice. So that was the idea in the context of how these three generation of rights, or you can say the generations of a right actually kind of categorized or understood in the international human rights discourse. Now, as I said, that in the 1990s or from the 90s, 70s onwards, what we find is that the non-Western groups and voices started to gain more influence in the international community at the international level, and therefore a radical shift also occurred in the understanding of human rights. How do we actually categorize, or how do we actually promote, or how do we actually propose the very idea of different types of human rights? Now, developing countries, but thus kind of shifted their emphasis on making human rights a more socially relevant. So, while civil rights or political rights were mostly concerned with the political climate in the Europe or the post-war period, this third generation of rights were kind of prescribed or geared towards making human rights more socially relevant. And therefore, the main question for developing countries was that it is not the human rights language should not be just based on a Western centric understanding of human beings or individual rights, but much more about the concerns and the rights of people living in developing countries. Now, categorizing right to development as third generation of human rights actually emphasize two important factors. And these two important factors are actually important in terms of understanding how we look into this particular right, the right to development as a human right in actual practice, in actual implementation. The first factor or the first emphasis is that human rights, human rights are in a constant process of developing as the world changes. So what you see is that looking into the categorization of human rights into generations, the first generation, second generation, and third generation, and nowadays we are also talking about fourth generation of human rights, is that there is no set standard, there is no set language that actually the set language of promoting the very idea of human rights. So human rights language is more evolving. So as the world changes, as the economic, political, or social and cultural situations of people living in different parts of the world change, the human rights language is also evolving. That there is also a change in the discourse of human rights. And therefore, while the right to development is closely linked or connected with the second generation of human rights, you can say that it is a more clear and a specific articulation of the concern or the most pressing issues of the people living in developing countries. So as the situation, as the position of developing countries kind of changed, so does the language of human rights, and therefore we find the emergence of a new category of human rights, the third generation of human rights, and more specifically, the right to development. And secondly, such a shift, the shift in thinking, the shift in the language of human rights also kind of indicate that or the emergence of human rights from below. So it was right to development or the third generation of human rights was not really rights or not really entitlements that were kind of prescribed or proposed at the top level. Means it was not really the rights or the language that were kind of discussed, that were proposed at the international level, at the UN level, or not, neither the developed countries actually proposed the right to development. So right to development was actually emerged from the third world countries, from a third world jurist, from the third world concerns, from third world state practices, from a third world political as well as legal thinking. So what does it suggest then that this third generation of human rights, and more specifically, the right to development is actually and the emergence of human rights from below and not from the top. And the top emergence of human rights from the top-down approach is more like prescribing or proposing or kind of recognizing human rights from the West, and then traveling or transporting those ideas and language of human rights to the South or to the East, but rather human rights are emerging from the sufferings, from the concerns, from the issues of southern countries or people living in developing countries. So this shift in language or the shift in focus, shift in thinking about how how the very idea of human rights, the very idea of development as a human right, has concrete implications. How we look into the practice of human rights as development. Now, what we find is that what we also need to keep in mind is that the Declaration on the Right to Development was a consensus document. It was not a document that was proposed and immediately accepted by by all the countries, by all the world leaders. So when the very idea of development as human rights was proposed, it was contested. Even it was the very idea was rejected by developed countries by the industrialized countries. Even many countries actually kind of argued that such a right never existed, and therefore we should not talk about the right to development as a human right. So it was actually a consensus between the developed and the developing countries. And not only that, this consensus was achieved by a paragraph by paragraph negotiation between different countries situated in different conditions, in different positions. So where developed countries were continuously contesting, rejecting the very idea of development as a human right, because that, according to them, recognizing the right to development as a human right will impose a legal obligation on them to support, to assist, to provide resources to developing countries. On the other hand, developing countries were more pressing for some kind of legal obligation that can be imposed at the international level, and more specifically on industrialized countries to fulfill their obligation at the international level in terms of providing resources, in terms of providing technologies, in terms of assisting, or in terms of providing development aids. So you can see a contestation of ideology or a contestation of language that were kind of occurring at the time of the negotiation. So we need to keep in mind that this document, this declaration on the right to development is a document that were negotiated on a paragraph by paragraph basis. So it is not really a wholehearted agreed text. So and therefore what we find, this document is not really clear. It is not really neat. Many language or the many terms which are used in the declaration are vague, not clear. Sometimes the focus is very broad. Some of the language is ambiguous. So some kind of ambivalence exists in the language of development as we find in the declaration. So therefore, we need to keep in mind when we're talking about right to development is that the document or the declaration actually lacks a clear, specific understanding of what does and the right to development as a human right means in actual practice. So it was more at an abstract level that this very idea of development as a human right was proposed, contested, and negotiated, and finally agreed. A compromise was made between the developed and the developing countries. And accordingly, what we find a document which is sometimes ambiguous, sometimes vague, sometimes unclear. Now, therefore, what we need to actually find out that what exactly the meaning and the substance of the right to of the human right to development that we actually need to follow, or that we actually can implement or kind of realize in actual practice. Now, having said that the document is a vague document, the declaration is a vague, many of the legal provisions, many of the provisions of the declarations are actually ambiguous. There is no clear direction, no clear instructions how these rights should be implemented or how these rights should be actually enforced in practice. We can make um, four propositions. And these propositions I have kind of already pointed out, but it becomes more important to clearly specify what these propositions are. So first proposition is that the right to development is a human right. So there is no doubt about this understanding. So it remains very clear from the language of the declaration that right to development is a human right. Okay, and there is no doubt, no ambiguity regarding this understanding. Secondly, the right to development is a right to a particular process of development. And this is very important in terms of what kind of processes should be adopted what kind of processes should be put in place in terms of procedure, in terms of um, um, accommodating the participation of affected communities, in terms of listening the voices of those affected people. So what kind of processes? Is it a political process? Is it an economic process? Is it a social process? That remains unclear. But what we find very clearly articulated in the document or in the declaration is that development is a process. And what kind of process is that? That remains unclear. But all human rights and fundamental freedoms can be fully realized when this process is accepted, or when this process is put in place. So there must be some kind of process put in place that will actually lead to the implementation or the realization of human rights in practice. Thirdly, the meaning of exercising these rights means the rights enshrined or kind of prescribed in the declaration, or more specifically, the right to development, which includes the right to process and right to participate in the process of development, which includes the right to participate in whatever process that may be in the implementation or in the enforcement of the right, um, must be consistently with the freedom. So the freedoms, the right must be exercised consistently with the freedoms. And what does it imply is an effective full participation of all the individuals concerned in the decision making and the implementation process. So that means that those who are affected, those who for whom the development is a matter of concern, they must get an opportunity to fully participate in the decision making about the development process. So first, there must be a process, and those who are concerned about the development, those who are concerned about their own development, those who are concerned about a particular process of development, they must be accommodated, they must be given an opportunity to actually participate in the decision making about the development. So what kind of development project is beneficial for me or beneficial for a particular community, we must, or I must have chance to actually say that whether this particular development project or this particular development process is beneficial for me or not. So there must be a participation in the decision making regarding a specific process of development, and also in the implementation process. So the implementation of the right to development is not just about a top-down approach in the sense that only the state or international organizations or regional organizations or state authorities will simply adopt adopt a development project, and therefore should be imposed upon the people, but rather the people or the individual or the community who are actually concerned about the process must be also taken into consideration, must also be integrated in the implementation process. So that is the third aspect we find, this third proposition we find from the declaration. The fourth proposition is that the right confers unequivocal obligation on the duty holders. So who are the actually duty holders according to the declaration? So the declaration actually clearly says that on whom the duty actually rests in terms of implementation, in terms of providing or kind of proposing and the development project. So the first duty remains with the individual in a community. So if a community is thinking or kind of proposing a particular idea of development, then the duty on the individual or the community is to actually create a condition where full participation can be provided in the decision making as well as in the implementation process. At the national level, the duty holder or the primary obligation is with the state. So therefore, the state must create a condition where all the concerned individuals, the concerned communities must be accommodated in the implementation process, in the decision-making process. And at the international level, it is the states from all the states in the international community, all the states in the world, as well as international organizations, and to some extent also the transnational corporations, different international institutions, regional organizations. So at the international level, the duty is actually rest with the actors, international actors, or those you can say the whole international community in terms of creating a condition where a meaningful participation can be achieved in the decision making as well as in the implementation process, the particular development project. Now, having said all these propositions and also what exactly the meaning and the substance, and the one of the question might arise in at this point is that, all right, so what about the legal status? So the declaration on the right to development is simply a declaration. So it is a non-binding document. And probably some of you are familiar or some of you are aware that a declaration is generally a non-binding document. At the international level, at the UN level, a declaration has no legal binding force. And therefore, exactly what is the legal status of the right to development? Is it actually enforceable in actual practice? Can the people, the individual, the community whose right to development has been affected by the duty holders or not fulfilled by the duty holders, can they enforce these rights in national courts or in different international forums? So that is one of the most important questions that we need to actually understand. And if a document or if the declaration is not legally binding, if it is not legally enforceable, then there is no legal obligation on the duty holders or the duty bearers that they actually need to follow the very idea of development as a human right. They have no legal duty to actually protect, to respect, and to observe the human right to development. But the only treaty, only binding treaty that we find is from the African continent. So in the African Charter on Human and People's Right recognizes, and it is a binding legal document, and it recognizes the right to development. So according to the African Charter on Human and People's Right, right to development is a legally binding, enforceable right. Okay. So people or individuals or communities living on the African continent, they can actually claim that they have a legally enforceable right. Further, in 2003, as you can find here, that an additional protocol was added to the charter, the African Charter, which further actually strengthened the right to development in the African continent. Now, these documents are obviously, as you can understand, that only binding on the African continent. Only the people living in that continent can only claim the right, and they can only enforce the rights against those African nations or African countries that are party to the African Charter. Now, then the question arises, what exactly the status of the right to development? And that means the right to development, a declaration on the right to development is not really an enforceable binding document. And therefore, it means that people living in other continents like in Asia or in Europe or in Latin America, they do not really have any enforceable legal right that can be called a human right to development. Now, one can, however, make a relation between the right to development and the UN Charter. An UN Charter is a binding legal document. So any country or all the countries in the world who are member of the United Nations, the UN Charter is a binding document for them. And Article 55 of the UN Charter clearly states the importance of social progress and development and respect for human rights and fundamental freedoms, while Article 56 stipulates joint cooperation for these purposes. So you can see that Article 55 and 56 of the UN Charter jointly actually points out the importance of social progress and development. Obviously, it does not talk about a specific human right to development, but it puts emphasis on social progress, on development, on international cooperation in terms of achieving this progress, in terms of achieving the development. Further guidance can be found in Article 11 of the International Covenant on Economic, Social, and Cultural Rights, which says that rights of everyone to an adequate standard of living and the continuous improvement of living conditions. So as you can see, the very idea of development, if the very idea of development is about improving people's life, people's condition, then obviously this particular article actually makes sense in terms of giving force, in terms of giving credibility to the very idea of human right to development. And then again, one can also point out the Vienna Declaration of 1993. Again, this Vienna Declaration is not really a binding document because it's simply a declaration. However, the Vienna Declaration actually provides a reflection to a new consensus on the right to development and reaffirms the right to development as a universal, inalienable human right. So again, in the context of the international human rights debate or human rights language or discourse, one can also say that the reaffirmation of the right to development as a human right, as an universal human right and inalienable human rights has been kind of confirmed or reaffirmed by the Vienna Declaration in 1993. That is again and not just the Declaration on the Right to Development of 1986, but the later progress, how the international community actually accepted the right to development as a human right. Um, and one can obviously argue that, again, the Vienna Declaration is not really a binding document, but reaffirmation of the right to development as an universal, inalienable human right actually confirms that there is a human right, and that is the human right to development. What we find from this this language or the participation, I mean, the language of declaration, what we find from the reaffirmation of the right to development as a human right is that a continuous emphasis on participation. And what we find here that what exactly the meaning, I mean, in terms of understanding, or in terms of finding out the substance of the right to development, what we find is that what constitutes development is largely subjective. And in this respect, development strategies must be determined by people themselves and adapted to their particular conditions and needs. And this language actually kind of puts emphasis on the participatory nature of development. So when it comes to the implementation, when it comes to the realization of the right to development, what we need to keep in mind is that in actual practice, it is not just about an abstract right to development, or it is not just about saying or talking about universal, inalienable human right, but rather the right must be subjective. And whose right it is actually. And the right to development is important for those whose condition or whose interest is at stake, who actually wants to claim that right. So, in terms of implementation, in terms of realization, who matters most is a is a people who are subject of development, and their participation is more important. And not only that, their participation in decision making, so that they can shape, they can actually decide what kind of condition they want for themselves, what kind of development they want for themselves. And this emphasis on participation is actually not so much about a right to improvement of the material condition, but the right to have a voice. And what does participation means in actual practice is not that it is all about improving the economic status. It is not about improving the material condition of the people whose life is affected, but it's more about having a voice, whether their voice has been heard in terms of decision making, in terms of participation in the implementation, in terms of how the development, how a particular development project is going to affect their life, what kind of whether the project is actually going to bring any benefits for them. So it is more about creating a space where people or individuals or community can actually participate and provide their voice or give their voice, or actually their voice must be listened by those who are making policies or those who are formulating the development project. A major substantive achievement of the global consultation. So I think I moved a little bit faster. Okay, so I think I can miss the slide. It's just like that. So, what we're talking about participation in terms of implementation, in terms of enforcement of the right to development, what we need to look at is that what kind of steps have been taken at the international level, what kind of steps have been taken at the national or at the regional level in terms of implementing the right to development. So when it comes to implementation, several steps actually have been taken at the international level, at the UN level. So what we find is that following the Declaration of the Right to Development in 1986, and different UN organs actually and actually, taken several steps in terms of promotion, in terms of implementation of the right to development. And one of the most important, there are several steps, and there are several kind of proposals, discussion, debate, and dialogue actually happened or occurred at the UN level. But for the interest of, in the interest of time, I couldn't actually include all of them. But what I found is the most important in terms of implementation, in terms of promotion of the right to development at the UN level, is the 1989 Commission on Human Rights proposed global consultation. And this global consultation was proposed by the Commission on Human Rights in terms of finding ways, in terms of finding principles that can that can actually lead to the realization of the right to development. The purpose of this global consultation was to focus on the fundamental problems posed by the implementation of the UN Declaration on the Right to Development. And therefore, this global consultation actually took place in Vienna in 1990. And the global consultation actually produced a report. The report clearly says that the concentration of all economic and political power in the most industrialized countries is an obstacle to development and is perpetuated by non-democratic decision-making processes of international economic, financial, and trade institutions. So you can see from here, from this statement from the report, that what the report found is that a non-democratic decision-making process means where there was lack of participation, where there was no scope for participation of people or individuals or communities who are affected by development projects or who are affected by development in practice. Not only that, it also pointed out the concentration of economic and political power. So this various statement actually reflects the views and the opinion of developing countries, how how the interests, how the concerns of developing countries were marginalized in international policy making or international development thinking or international development practice. The participants of the global consultation also kind of emphasize that what is critical of international development strategies is that most of these development thinking and strategies are actually oriented merely towards economic growth and financial considerations. So the international development thinking was in the 1990s or just after the adoption of the right to a declaration. At that time, the development thinking was much more biased towards economic progress, economic growth, or financial considerations. What they noted also that these kind of financial or economic thinking often resulted directly or indirectly in violation of human rights. And so what does the report actually suggested that a one-way thinking that one size fits all, and that is only economic progress, only economic development, or financial considerations in development, the profit-oriented mindset in development practice actually leads to the violation of human rights. And therefore, kind of this is the second, I think, kind of, I kind of missed the slide. So what they pointed out that what constitutes this global consultation actually pointed out that what we need to keep in mind is that the very idea of development actually need to become more inclusive, need to become more participatory, where people can actually think about their own development, think about their own benefit, can shape the development project, can raise their voice that what development projects is beneficial for them and what benefits they can actually realize from a particular development project. Now, the global consultation was actually refining the concept of participation that was included in the declaration. And it was argued that participation must be active, must involve genuine power, as well as genuine ownership and control of productive resources, such as land, financial capital, and technology. So when I was kind of pointed out in the last session, the yesterday's session, and I kind of provided two examples, one from Kenya and one from Indonesia. Many of you actually, I think one of you actually kind of raised a question or asked a question that how do we make a balance in terms of development, government or national development projects which are beneficial for the larger group of people or the larger number of people. And even if, or because of a development project, or if some communities or some people are kind of affected or disadvantaged, then how do we actually make a balance, or where do we situate the very idea of right to development as a human right? Now, you can see that from here that it is not just about the benefit, the cost and benefit of development, but it's more about giving a voice. It's more about creating a condition where meaningful participation can be achieved, where people for whom the development project has been initiated, or kind of for whom the development project has been planned, whether they have the control or genuine power to actually control their resources, such as land. Now, when it comes to productive resources, the control of productive resources, such as land, and those two debatable examples I have provided in the beginning, where obviously the question was about the encroachment or kind of taking of productive resources, such as land, from certain communities. And the question here arises that whether the development project in Indonesia or the development project in Kenya, um, that were initiated or planned by the governments of these two countries, whether those development projects or those development planning actually provided or actually created a condition for participation of those people who were affected by the project, whether in the development process, or in implementing the development project, whether people had the choice, or the community had the choice to actually control their productive resources, actually had the control to control over their land, which were the object and the subject of development project. So here, the question is not really how much benefit the affected people, or how much financial return people or the community is going to receive from those development projects, or it is also not the question of how a large number of people is going to get the benefit of those development projects, but rather the question is whether the authorities who actually planned or kind of proposed and initiated and implemented those development projects created a condition for people or the community to participate in the development process. Whether there was a condition for them to raise their voice, to raise their concern, to participate in the decision making of the project, how the project should be implemented, whether the project should be carried out or implemented at all, whether they were given control, or they had the control over their productive resources or not. So those questions are more important, um, rather than making arguments that how actually a particular project can benefit a larger number of people, or a large number of population. But that is not really the question. The question is that how participatory the process of development is. If there is no scope for participation, if there is no scope for raising the voice, or if there is no scope for decision making, no scope for participation in the implementation process, then obviously that kind of goes against the very idea of development as a human right. The relevant factors in terms of evaluating participation, so whether there is a condition for participation or not, is to look into um, the representativity on accountability of decision maker, or the decision making bodies. So whether in terms of proposing, in terms of implementing a development project, whether the people who are going to be affected, the people whose productive resources are going to be acquired, going to be taken by the authorities, whether the question then arises in terms of participation is that whether the people were actually represented in the decision making, whether the people actually sat in the decision making in terms of planning, in terms of implementing, in terms of deciding how the project should be carried out, and also the accountability of decision making bodies. So those who are making the decision, whether they are accountable to the people. So that is again one question we need to kind of try to find out, that at the national level, at the international level, at the domestic level, whether those who are implementing or those who are managing development projects, whether they are actually accountable to the people for whom the development project has been planned, for whom the development project has been kind of initiated. Secondly, the decentralization of decision making. How the decisions are made? Is it the decision made by one specific state official, state authority, or government authority, or the decision making has been decentralized or divided or kind of delegated into different organs, including the people who are affected or who are for whom the development project has been planned. So that is again the question: how decision is made. The public access to information, so the community, the people, the individual for whom the project has been initiated or planned, whether they have access to all the information regarding the development project, whether the government has provided all the information regarding the project to the people, to the community, to the affected community. And fourth, responsiveness of decision makers to public opinion. So whenever there is a public opinion, whenever there is a public outcry, whenever there is a public criticism of a particular development project, whether the government actually listens to those criticisms, whether the government or the state authorities actually listens to those voices, to those arguments or those opinions. So that is so all these four aspects are extremely important in terms of understanding the very idea of participation, or the very idea of participatory development proposed in the right to development. Now, what we also find from the global consultation is also an emphasis on policy making. So at the international level as well as at the domestic level, what is also we need to keep in mind is that the development projects or development decision making is actually occurs at the policy level. And this policy prescription, the policy discussion happens in different forums, in different places, at international organizations and different international institutions. It can happen also at the national level in different state or organs, state authorities. So national development policy should provide expressly for the protection of human. So whenever these development policies, development planning are actually initiated or kind of are discussed at the national and also at the international level, human rights protection must be clearly integrated or must be clearly specified itself in the policy level, in the policy prescription. So the state governments, the state authorities must also include the protection of human rights, the very idea of development at the policy level. And also not just including this the idea of development at the policy level, but also creating mechanisms. This is also a mechanism for strengthening democracy. And once the democracy, once the policy discussion, once the policy making becomes democratic, then there is a scope for full participation of all social groups. So policy making should not be limited only within the state bureaucracies, within the offices of the state governments. Policy making must also be open, must be participatory. So whenever development policies, development planning are kind of initiated or are kind of proposed by governments at the national level, or by different international organizations such as the UN or other UN organs such as the UNDP, then those policymaking must be open for participation by different social groups such as the NGOs or any other representatives of different marginalized communities. There must also be an international implementation and monitoring mechanism that are of universal applicability. So not just policy making also at the international level, at the national level, there must also be a policy making policies towards implementation. So it is not simply including human rights language or the protection of a right to development, the protection of full participation in the policy making, in the development planning, development decision making, but also there must also be some kind of a monitoring mechanism. There must also be an implementation mechanism that can be followed in practice. So whenever those monitoring mechanisms or implementation mechanisms are put in place, then obviously it will create some kind of check and balances that how the development how the development project is actually progressing, who are actually affected by the project, and what kind of steps can be taken to actually address those issues of development. Now, in terms of this universal implementation and monitoring mechanism, um, there is also obviously some kind of debate between the North and the South on what kind of mechanism, what kind of implementation procedure is acceptable to the North or developing countries and the developed world. That is again obviously a subject of debate. But at the global level, at the UN level, the discussions are also going on, or kind of debates are also already going on continuously happening in terms of what mechanisms, what kind of monitoring system can be put in place in terms of scrutinizing the national development projects, in terms of the effect of national development projects on human rights. So the global consultation report that kind of provided or kind of came out in the 1990s, as a whole, was characterized as a positive step and a valuable basis for continuing the examination of possible implementation measures. So this global consultation can be said that as a positive step, and many international organizations, many northern governments or developed country governments actually accepted the global global consultation report as a valuable basis for thinking about implementation, thinking about monitoring mechanisms, or thinking about what kind of mechanisms can be put in place to actually monitor the different development projects at the national as well as at the international level. Now we are already discussing for the past, I think, almost past 1.5 hours, that different steps can be taken to actually implement. Different steps can actually be taken to realize the right to development as a right to development at the international level. Having discussed the global consultation report, having discussed um, the other propositions for development of the propositions for implementation, what we find is that even today, the current practice is that in the current practice of development thinking, in the current practice of the human right to development is the main problem, or the major problem is the implementation. And the main problem, what we find in terms of implementation, in terms of understanding the current practice, is that the right to development is neither universally protected nor respected. National, even international implementation of the right to development can be characterized as uneven, even sometimes weak. To the vast majority of the population in developing world, and those who are in the most need of protection and support, right to development remains unknown, and for them only an abstract principle, an abstract idea. So if we want to make the right to development as an integral part of the human rights discourse, then it must contribute to empowerment of those people who are, and so that they become capable of demanding their rights and of dealing with their needs and problems. So in the UN Declaration on the Right to Development, development has been recognized as a claimable rights because it comprises the entitlement to participation during its process. So in fact, what we can say that right to development is a claimable right. And once we think about the relationship with the connection between the UN Charter, the International Covenant on Economic, Social, and Cultural Rights, then obviously we can propose or we can argue that right to development is a claimable entitlement. And what is this entitlement is that to fully participate in the development process. The declaration regards those affected by development policies as the right holders. So those who are affected by the development projects, they are the right holders. And once we recognize those affected people as right holders, that automatically reveals who are the duty holders or who are the duty bearers in terms of fulfilling, in terms of providing protection to the right holders who have to be protected from losing their entitlements. So if the people who are affected by development, who are affected by whether planned development, whether unplanned development, once we recognize them as right holders, then therefore the right to development is a mechanism that will obviously protect them from losing their entitlements. The declaration further stipulates free and meaningful participation, a fair distribution of possible benefits as necessary freedom and entitlements. So what we find is that even today, right to development to some extent remains as a simple rhetoric, simply an abstract language for many people. However, if we understand the right to development as a form of entitlement, then obviously those who are affected by development projects or affected by the planned or unplanned development, they are the right holders. So we are close to time, so I'll briefly kind of summarize with this particular slide. So what we understand and how we want to summarize, specifically keeping in mind the current practices of development, is that our right to development is a legal resource and it is also a political instrument. And what do I mean by legal resource? And what do I mean by a political instrument? So the right to development as a legal resource originates from the UN as an internationally recognized or internationally authorized agency to declare such a right. So when the right to development actually originates from the UN, then it obviously has a legal basis. The UN Declaration provides legitimacy in efforts to create more than mere acceptance of the right in the international community. Moreover, the right to development acquired the character of the legal resource intended to function as a legitimate basis for its enforcement and implementation. It also means that states, as duty bearers, must guarantee further lawmaking and create enabling conditions for the realization of the right to development. So, the right to development, as it emerges, as it recognized, as it comes from an international organization which has a legal authority to actually declare something as a right, it obviously has a legal basis. And once we recognize the right to development has a legal basis, and therefore it is a legal right that can be enforced, that can be implemented in practice. And once we have the legal basis, once we recognize the legal basis of the right to development, then it imposes a legal obligation on the duty bearers or the duty holders, which are mainly the states at the national level, other states at the international level, or jointly, cooperatively, collectively, international organizations. So they are the duty bearers, and therefore they have a legal obligation to actually fulfill, or realize, or implement the right to development. On the other hand, as a political instrument, the right to development must be regarded as standard of legitimacy, on the basis of which the right holders may challenge any execution of power that violates freedom and entitlements incorporated in the declarations. So, right to development can also be described as a form of political instrument, and those who are affected by the development projects, they can use this implement to claim their rights, to protect their rights against those who are actually violating their rights. It is also important to note that the right do not function as automatic guarantees. So right to development, simply it is recognized by the UN, simply it is recognized in a declaration, does not make it or does not provide an automatic guarantee of protection, but rather an instrument of mediation and negotiation of claims. So whenever people have claims, whenever people have entitlements, the language of right can only provide a guarantee, or only can provide some avenues for negotiation or mediation. Thus, the right holders are the primary actors. So it is not the duty holders, it is not the international community, or it is not any specific individual, or it is not really a state authorities, but rather the right holders, means those who are affected by the development, those who are affected by development projects. Those whose rights are actually affected, they are the primary actors who can act and present claims based on their presumed entitlements. It is the people, the community, or the individual who have to act, who have to claim their entitlements, who have to claim their rights. Once they make their claim, once they challenge the authorities, or those who have the power of execution, or power of executing those development projects, only in that context, only in that situation, the right to development can only be realized, can only be implemented. So that's where I stop now, because it's already 9:05. So I do not want to actually continue further.
Okay, Sir Mizanur, is there still slides left that you want to explain to us, or is it enough for today?
Sorry, I didn't get your question.
I mean, it's already 9 p.m., but if you still have some slides left, you can continue if you want to.
Yeah, I have, but so I don't know whether I can continue, because it's already 9, and and the students or those who are actually present, I don't know whether they're willing to actually stay for longer. So if they do not want to stay longer, then I can stop. Or if they want to still um, want to stay, then I have them probably in a two, three further slides, just to kind of point out a few other things which I was kind of thinking to kind of mention.
Okay, sir. If that's the case, then perhaps we can expand for 5 more minutes for
All
you
right.
to provide the closing statement, and after that we can move to the question section.
Okay,
Please.
sure. Okay. So in this slide, I was kind of talking about that how what is exactly the problem with the implementation? What exactly the challenges we are facing in terms of implementing the right to development or enforcing the right to development in practice? So what we find is that this idea, I mean, the right to development was a continuous effort on the part of the UN to actually promote, actually realize, or actually operationalize from the 1990s onwards. And not only that, if you just look a little bit deeper, then what you find is that even one of the UN agency or UN organ, the UNDP, the United Nations Development Program, actually implemented or actually kind of followed the essential elements, the essential principles of the right to development. So if you look into the reports that are published every year, the UNDP publishes annual report every year called the Human Development Report. And in that report, you will find that it essentially, the UNDP actually essentially integrated, or you can say kind of accepted, or to some extent implemented the very idea of development as human rights. Not only that, we can also find that the UNDP as the main UN agency in terms of international and development policymaking, the UNDP actually integrated all these very ideas of participatory development and full participation in decision making, all these principles or all these ideas of right to development into their own policy making. The European Commission also incorporated some of the elements of the right to development that we find in the UN DRD, the Declaration on the Right to Development. And not only that, the European Convention actually also entered or kind of entered into a Lome 4 convention, more a specific convention, which is more geared towards implementing or kind of integrating the very idea of development as a human right. At the European level, we also find the OECD, the Organization of Economic Cooperation and Development, also integrated the very idea of development as a human right. Having said this, the developments at the international or the regional level, what we also kind of need to keep in mind is that inclusion of the basics of the right to development, such as participatory development or a fair distribution of the benefits of the development, in practice appears to be highly problematic. So while these organizations at the international level or the regional level actually integrated or implemented some of these principles, some of these ideas into their policy making, implementation in other contexts or implementation in the national context remains highly problematic. In fact, it can be said that instead of creating improvements in respect of access to resources or increased opportunities for the right holders in development policies, reality is that what reality actually reflects is that development hazards. And why I'm kind of saying that the reality is more about development hazards rather than protection, or rather than providing opportunities, or rather than creating um, a condition for the protection of the right to development, is that um, the first two examples I have kind of provided in the beginning, and obviously I will discuss more um, um, development hazards tomorrow, which is more about the contemporary challenges and issues. So the main focus of tomorrow's discussion would be on development hazards. So what we discussed today is more about how the very idea of development as human right has been implemented at the international level, at the national level, what kind of propositions we can make, or what kind of principles we can actually propose in terms of how the right to development has been or has to be implemented in practice, or how actually it has been implemented in practice at a certain level, but more remains to be done. And therefore, what we see is that having discussed all these ideas and principles, and also efforts towards implementation, efforts towards operationalizing, efforts towards integrating these ideas and principles in development policymaking, we can still think about how development actually creates or brings more hazards, and how do we actually understand those hazards. And that's why I posed a number of questions in the beginning. Whose voice actually matter? Is it possible to create a platform? Is it possible to create a condition where the voice of those people who are affected by development can be integrated into the development policymaking? So what I want to kind of end, what I want to say in terms of ending the session is that in many contexts, having all these ideas and principles of the right to development as a human right, in many contexts, in many situations, development brings more hazards than the protection that need to be provided to those marginalized, those vulnerable people. And therefore, instead of respect, instead of protection, instead of observance of human right, what we find is that a more a practice emergence, or what we find is that development in practice is actually bringing more development hazards and imperiling individuals, communities considered to be the holders of the right to development. So we have recognized who are the holders of the right, and their rights have been recognized. Their rights have been integrated or implemented, recognized in different declarations, different international forums. Their rights have been a kind of integrated into development policymaking at the international level, to some extent also at the national level. But instead, so despite having all these developments, then despite having all these understanding, what we find is that the current practices of development is bringing more hazards than the respect, the protection, the observance, the realization of the human right to development. And that I will discuss in more detail in tomorrow's session. So that's where I actually want to, this is the place I want to stop here.
Okay.
Yeah, Anissa, so yeah, that's
Yeah, thank you so much, Sir Mizanur, for the very comprehensive and excellent explanation for us. Unfortunately, it is the time that have to limit our discussion session today.
yes, yes.
Yeah, we already have one question on the chat, but before going to the question, I would like to let you know that
Okay.
while you were explaining things for us, there are some lecturer from Faculty of Law that has
Mhm.
joined and listened to your explanation, such as Miss Vita, Miss Utari, and also Prof. Alfi Shahrin, professor from Criminal Law. Yeah,
Mhm.
I would like to let you know that your contribute to our faculties is very, very appreciated from us. And we would like to have another collaborative event, maybe like
Sure,
join researchers or things like that. And perhaps we
sure,
can talk more about MOU or MOA between our faculties, so we
sure,
can so we can
sure,
make it more interesting. Perhaps you can come to our faculty directly, or perhaps we can come to you. Yeah,
sure,
we can talk about this later on
sure,
another event. Okay.
sure.
Shall we move to the question? But
Yeah, sure.
before that, please turn on your camera, students. It's almost finished. Please engage with us a little bit more. Yeah, turn on your
Yeah, so
camera,
yeah,
please.
I was observing the time, but at a certain point of time, I actually forgot to look into my watch. So today, I wear a watch and I changed my time to Indonesian time, okay, so that I can follow up. But I was
Uh,
watching, but at a certain point of time when I was discussing, I forgot to see my watch. And I suddenly saw, okay, only 5 minutes left. So I was kind of a little bit, moving faster in terms of
yeah.
kind of finishing the discussion.
Hearing that, I am personally in touch with your excitement to teaching us. Thank you so
Thank
much.
you. Thank
Yeah,
you.
you apa ya? You will go far and beyond to be more prepared to explaining to us. I hope the serve we provide to you is acceptable and not disappointing you at in um, any details. I hope.
No, no, no. Yeah, so absolutely fine. I have no problem. As you know, I'm not a very demanding person. So
Yes, since the very beginning,
I
you are so supportive.
I remain very happy with the small things. So it's not really an issue for me at all. And as I know, I enjoy teaching, discussing, complex issues, problematic issues, contested ideas. So I always enjoy discussing these things. So it's also an enjoyable moment for me, an enjoyable experience for me.
Okay, sir. Shall we move on to the question? There is
Sure.
one question from Mawar Pangaribuan. Her question is, there will always be a relationship between human rights and development because development is part of human rights. How the role of the state can realize human rights equally as part of world change, while there is a conflict between the recognition of human rights at the UN and other countries such as Indonesia. For the example is the UN recognizes LGBT human rights, while Indonesia does not. So basically, the question is about the different perceptions on understanding the human rights. How can we find agreement on international level while in national itself, we still face the different meaning or idea about human rights itself? Please, Doctor.
Right. Right. I think I will kind of, in terms of responding to the question, I would like to bring um, the very discussion that was happening in the 1980s or 1990s that regarding the idea or the argument of cultural relativism. So there was a debate regarding the nature of the universal nature of human rights, or human rights are culturally relative, means but in terms of human rights protection, whether culture is important in terms of recognizing human rights, in terms of protecting um, cultural rights. And that specific debate regarding the universality, on the one hand, the universality of human rights means it applies or it is protected everywhere in the world, or human rights can be more culturally specific, such as considering the Asian countries like Singapore, where this very debate was started, the very idea of cultural relativism. So whether human rights can be culturally specific, and I think in this debate or this conflict between the universality of human rights and the cultural relativism argument is not really a problem, because what we need is a cross-cultural dialogue. So once we initiate or once we have a cross-cultural dialogue, probably we can come up with a more shared understanding, a more shared view of what human rights are, and what human rights can be protected or should be protected in a particular country, in a particular religious or ethnic or cultural context. So human rights are universal, but at the same time, because it is a language, the language of human rights is universal. It deserves or it requires universal protection. However, at the UN level, or even the covenants or the UND or UDHR, they never really impose or never really force countries to actually protect or to recognize certain rights which those countries or which those governments are not comfortable in terms of providing protection. So I think within the language, within the universal language of human rights, there is a scope for accommodating the cultural relativism argument. So if a country it's not just the Indonesia, even Malaysia, if I can Malaysia, even in India, LGBTQ right was a long debate. Even in many African countries where LGBTQ rights are not recognized, but that doesn't mean that that country completely ignores the human rights or the protection of human rights. So I think within the very idea of universality, we can also include the cultural relativity of the protection of human rights. So the human rights, I mean, the human rights covenants, the human rights documents do not really force countries to actually accept or to actually protect something which are which are not guaranteed in that country's constitution, which is not recognized in that country's constitution. So if a country's constitution actually recognizes certain rights and certain rights are not recognized, then obviously that might to some extent create a kind of conflict or kind of incompatibility, but that incompatibility is actually justified because the constitution is the supreme law, the fundamental law in a particular country, and therefore as long as the constitution prescribes something, it is, I think, acceptable in that context.
Alright, sir. Jadi pada intinya teman-teman, pertanyaannya adalah bagaimana kita bisa menemukan kesepakatan pada tingkat internasional ketika pada level nasional saja kita masih menemukan perbedaan mengenai apa itu hak asasi manusia. Contoh yang dibawa adalah mengenai persepsi tentang LGBT, di mana United Nations (UN) menganggap bahwa LGBT itu adalah bagian dari hak asasi manusia, sementara di Indonesia kita sepakati bahwasanya hal itu masih menjadi perdebatan dan masih ditolak gitu ya. Jawaban dari Dr. Mizanur adalah bahwa pada intinya UN tidak memaksakan masing-masing negara untuk secara mentah-mentah mengimplementasikan apa yang disepakati sebagai human rights kepada masing-masing negara. UN understand, dimengerti bahwasanya masing-masing negara memiliki budaya hukum tersendiri, kearifan lokalnya, ideologi nasionalisme yang ingin dijaga, termasuk juga pengaruh agama dan juga budaya mungkin, sehingga tidak dipaksakan. Prinsip universal itu tidak berarti bahwa ya harus dengan serta-merta berlaku untuk semuanya, tapi juga tetap memperhatikan prinsip nasionalisme begitu. Kemudian juga yang menjadi pembahasan adalah bahwa Bukan berarti menolak LGBT, artinya mengabaikan human rights, karena pemahaman mengenai hak asasi manusia harusnya lebih kompleks dan lebih lebar lagi, tidak hanya sebatas mengenai pemahaman LGBT. Beberapa negara seperti Malaysia, Afrika, dan juga India pun menghadapi hal yang sama begitu. Tidak semua nilai-nilai universal bisa masuk ke negaranya, pun begitu juga dengan nilai-nilai nasional suatu negara harus terkadang dispesialkan begitu posisinya ketika berbenturan dengan hukum internasional. Okay, Dr. Mizanur, I just finished translated your answer
Right.
in
Right.
Indonesian.
Just for your information, India, I mean, in India recently, I think it's a few months back or just a year back, the Supreme Court of India actually recognized the LGBTQ rights, but obviously it is not the state organs, not the state authorities or not the government, but the recognition came from the court, not by way of implementation of human rights through law or through legislation or through not by passing any law, but it is just a court decision. So Supreme Court of India recently recognized the LGBTQ rights in India. But I think what is more important in this context is that I should have mentioned that in the UN system, if a country wants to put a reservation on any particular provision at the time of signing the covenant, at the time of signing that document, or the time of ratification of that document, that actually exempts that country from implementing that particular provision in that country. So, for example, in the context of Indonesia, if Indonesia or the Indonesian government wants to actually put a reservation on a particular provision either from the ICCP, I mean, the two covenants or any other, human rights documents, then obviously that is an option for countries that they can put reservation. And putting a reservation means that that country is not bound to implement that particular legal provision or that particular right in their own country. So that also gives a leeway. That also gives a certain scope to countries how they can actually avoid implementing, or how they can avoid in terms of complex issues where the government or the people are not really comfortable in terms of recognizing certain rights. So that way the countries can actually put in place certain exceptions or certain reservations at the time of signing the human rights documents, or the time of ratifying the human rights document. That is another option open to countries.
All right, sir. Thank you so much for widening our perspectives toward human rights and LGBT, and also the current practices in India that you were just mentioned it. But still, again, it's time to have ultimately limit us. It's already 30 minutes prior the time that we are closing.
Yeah,
so it means
more than 30 minutes.
Yeah, it means we already take 2 hours of your precious time to share with us.
No problem. It's okay. Because in the beginning, we generally in the beginning we miss about 5-10 minutes. We miss in the beginning, so it's okay if it goes a little bit beyond the fixed time. So it's okay in that case.
Yes, sir. We missed 10 minutes. We missed 10 minutes, but we give us more 20 minutes. It's still more.
Yeah, it's mainly because of technical issues. Because sometimes when I put my credentials on Zoom, it takes time to actually let me enter the main chat room, or the main room, Zoom meeting actually. So it takes some time to actually go into the meeting room, and that's where the delay happens actually.
Yes, it's okay, sir. We still have one more session tomorrow. So everybody, I wish you can also come to our very last session, but perhaps will becoming the most interesting one because we will talking about contemporary issues and challenges,
Yes,
such
yes,
some
that's
hazards.
the third one is the most interesting. How development brings more hazards rather than protection, rather than respect, rather than observance of the right to development. So we have the last two classes, we have discussed the theories, the principles, the abstract ideology or ideas of human right to development. We have talked about different efforts at the international, at the regional, the national level in terms of implementation, in terms of promotion, in terms of making the right to development more concrete. But what happens is when we look into the challenges, what exactly the challenges in terms of implementation, what exactly happening on the ground, whether the whether the right to development has actually been realized, or whether the right to development has actually been implemented in development policies, in development projects. So that's the focus for tomorrow.
Ya, besok adalah sesi terakhir kita, masih pada jam yang sama, 7:30 sampai juga jam 9, akan membahas mengenai isu-isu kontemporer dan tantangannya, beserta juga ancaman-ancaman, dan mungkin nanti akan ada usulan dari Pak Mizanur mengenai keterlibatan kita seperti apa dalam konteks penegakan hukum dan hak asasi manusia dibenturkan dengan pembangunan secara global dan juga mungkin secara nasional gitu. Jadi istirahat yang baik adik-adik supaya besok bisa menghadiri kegiatan kita dengan tepat waktu dan juga lebih fokus, mungkin juga lebih ramai ya. I think that's all for today, sir.
Yes, that's all for today. So thank you, and thanks to all those who are still in the session, because it's already more than 30 minutes, and many of you are still in the session. So I really appreciate your dedication or your devotion to the session. So that is very encouraging for me. Otherwise, many students they don't really want to go beyond the fixed time or the already pre-decided time. So that's really encouraging. Okay, so that's what we can finish here today, and we can we're gonna start tomorrow night and finish the 3-part session, the final session. Okay, so yeah, thanks everyone, and see all of you tomorrow again.
Thank you, sir. See you tomorrow.
Okay, thank you. Bye.
Ya, Pak Mizanur baru saja memuji adik-adik sekalian, mengapresiasi kesediaannya untuk stay lebih lama selama 30 menit. Jadi kalian juga harus tahu bahwasanya Pak Mizanur juga mengapresiasi gitu. Kehadiran kalian stay dari awal sampai akhir konsisten kurang lebih 30 orang gitu. Jadi tetap semangat membersamai final session, sesi terakhir besok ya. Sampai jumpa lagi besok dan selamat istirahat semuanya. See you tomorrow and have a good rest everyone. Please leave the meeting.
Thank you.